The first case to come before us is the State of Ohio v. J.B. Samuel Arroyo. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know, as I'll be keeping track of the time, and we'll try to alert you when you're moving into that rebuttal time. The arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourselves. You should not use the names of children, minors, victims during your argument. You can refer to those folks, should it be relevant, by initials or terms like the child. We have read your briefs, and we are ready to proceed when you are. So I would just ask appellant, do you want to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
Very well, then you may proceed when you are ready.
Thank you. We certainly seem to be in agreement here. The question is, what does a remand look like? I'm an advocate for my client, and so it's obvious where I come from. I did make a mistake in the brief saying the judge could give him probation on count 2. She can't. He's already sentenced to prison. You can't have a prison sentence. So the issue is any sentence between 6 and 18 months must be imposed. I think the remand should look like that. And of course, consistent with the previous sentencing, concurrent. Her Honor made no consecutive findings at the time of sentencing. She was free to, that was not part of the agreement. She could have said, she was at liberty to issue consecutive sentences, but she did not. She did not make consecutive findings.
How could we impose some type of sentence here at this court?
Pardon?
How could we give the court any input on what the sentence should be?
I don't know that you can, because maybe I'm wrong, but it seems to me the judge has discretion to sentence between 6 to 18 months. My guess is she'll go 18, but is it up to her to make that decision? I don't know. So I would think Her Honor has to make that call. I could be wrong. I don't know. I apologize, but I don't know the answer. I mean, if it was a post-release control issue, it would be very precise. But I do believe she still has the discretion. As a betting man, I bet 18 months, but I think it must be concurrent. And that if she decided to all of a sudden go consecutive, I would argue that's a vindictive sentence. So I'm looking for a remand that constrains the trial judge. With that, no more.
Thank you, counsel. You have your full 5 minutes for rebuttal.
Good morning, Judges. Mark Poza on behalf of the Lorain County Prosecutor's Office. The state has conceded in this matter that this was an illegal sentence. If the court has any questions, I would add, though, the issue of consecutive sentences was not raised by the appellant, so I don't understand why that's being raised today in oral arguments, but if the judges have any questions. Thank you very
Hearing
much.
none. Thank you.
Thank you.
Not specifically raised, but I think it's within the numbers of the argument that there must be a remand. So what must the remand look like?
Thank you both. Do you have a question?
I'm sorry, I do have a
That's
question.
fine. Counsel.
I must be missing something with the...
Question for me, Your Honor?
Yes, thank you. With the judgment entry that's attached to your brief, the sentence is 3 years. Okay, never mind.
All right.
I figured out the math myself, see? I apologize for taking up your time.
No. Thank you all.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk, of course, will mail a copy of that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you again.